Are you ready to open?
Good morning. The
Good
36th District
morning.
Court, the 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing of gum, or reading of any material, and also no driving. Thank you.
Thank you, officer. And ladies and gentlemen, please keep your device on mute until your case has been called. The court first now calls case number 22196427. This is Goldman Sachs versus Timka Willis. The matter is before the court, set on for a status and scheduling conference. Your appearance for Goldman Sachs, please.
Good morning, Your Honor. John Whitty, P66880 for plaintiff.
All right, thank you, counsel. Good morning to you. I'm looking for Ms. Willis now. Timka Willis is the name. This is related to a person living in the, I believe I saw in the city of Detroit on Longfellow. So
I'm here, Your Honor.
all right, what is your name, ma'am?
Timka Willis.
All right, thank you, Ms. Willis. All right, thank you. All right, so I took a look at this file, set it up for the status conference. It looks like to me that there is no dispute that there was a debt entered into. The defendant has indicated significant illness, disability related to a secondary to sarcoidosis, and have planned for other challenges that she's faced regarding personal life. That seems to be the position of this file. It doesn't seem to be a dispute that there is an indebtedness. Is that correct about the size of Ms. Willis?
Yes, sir.
Mr. Goldman, Mr. Whitty, I'm sorry. Anything at this time, sir?
No, Your Honor, we haven't spoken. I don't know if there's a chance of resolving, but there doesn't seem to be an issue about whether or not the money is owed. It really would become an issue of whether or not it can be paid or is collectible or not, but
Why don't we take a moment and go to a breakout room? Ms. Willis, it doesn't appear that you're contesting the debt. You're contesting, or you're pointing out that you have a substantial inability to pay. To the extent that you are on some type of federal disability payments, that would not be subject to collection if there were we have to find a way to resolve there is an indebtedness and there's not a dispute about the debt. Collection is a second issue. So I'm going to send you to a breakout room to talk with the other side for just a moment to see if there is a way to get to that conclusion on this, and then you'll be able to click back into the courtroom. So I'm sending you notice, Ms. Willis, to breakout room number 1. Counsel,
Okay.
And send that notice to you as well, sir.
sounds good.
All right. So I'll stand down on it. So go ahead and click in, Ms. Willis. All right, the court now calls Mr. Whitty. Did you get the notification, sir?
Not yet.
Oh, I gave it to the wrong person. That's
I'll take them out. I got it. Thank you, Judge.
Thank you. Mr. Bird, you would have gotten a notification, but don't go there, sir. All right, this is case number 22197760. This is Crystal Walters versus Maurice Branch. The matter is before the court on a petition for that has been filed for claim and delivery regarding an animal. All right, do I have Crystal Walters on this Zoom, please? Ms. Walters, Crystal Walters, say something if you're here. Do I have Maurice Branch on this Zoom? Maurice Branch, say something if you're here. All right, the matter is set on for 9 o'clock this morning. I'll strike at 9:30. Just 1 second here. I do see where the notification was given for the 534 courtroom. So I'm going to wait a few minutes and call that one again. So we're going to move on and we'll come back to that matter. All right, this is case number 22-186-883. This is DNF Associates LLC versus Hector Vasquez. The matter is before the court, set on for a review after the court signed an order reinstating the matter that the matter had previously been dismissed. Your appearance for the plaintiff in this matter, please.
Attorney Ashley Nelson for DNF Associates.
And your P number, if you will, Ms. Nelson, for the record.
It is P84103.
All right, thank you, Madam Counsel. Good morning to you.
Morning.
I am looking now for Hector Vasquez. If you on the Zoom or anyone representing Mr. Vasquez, please say something at this time. All right, I know I have this set on for 10:45, Madam Counsel. I'm going to wait a few more minutes because of that 534 directive and giving persons an opportunity to try and make their way here. And I'll come right back to you shortly on this one.
All right, thank you.
The court now calls case number 22-193-751. This is Beaumont Health versus Jasmine Chapel. The matter is before the court on an adjourned date of hearing relative to a motion for summary disposition in this matter. Your appearance for Beaumont Health, please.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Thank you, Mr. Burke, and good morning to you, sir. I'm looking now for Jasmine Chapel. I believe I see you indicating there. Good morning to you, Ms. Chapel.
Chappelle.
And good morning anyway, Ms. Chappelle.
Good morning.
All right, it's good to hear a good morning from you. All right, the matter is here regarding the motion to have this matter decided based upon there being a claim that there is no genuine issue of material fact. Counsel, you may proceed on your motion, and then Ms. Chappelle, I'm going to come to you and give you an opportunity to tell me anything you wanted to say in response. You may at this time.
Thank you, Your Honor. I believe, obviously, the motion speaks for itself. I did not see an affirmative defense raised by Ms. Chappelle in her answer. I am willing, as always, to have a breakout session with her and see if she and I can resolve it. However, I did not see a reply to my request for summary disposition, summary judgment that was filed by her or by any representative for her. And I, of course, defer to the court.
All right, I certainly favor, as well as the state of Michigan, the resolution of matters that when people can do so. Mr. Chappelle, I'm going to give you the opportunity to speak with Mr. Burke in a breakout room, see if you can get this resolved. Otherwise, I'll rule on the motion. See if you can work your differences out and come up with something that may resolve this. And if so, then that may be the outcome of the case. If not, then come back in. So I've sent you a notification, Mr. Chappelle, and Counsel, Mr. Burke, I've sent a notification to you as well. Let's take a moment to approach it in that manner, and then I'll see you on the other side.
Thank you, Your Honor.
Kirk, you got my notice?
I have not seen it yet.
Oh. Okay, I have you there. I'm gonna send you another notice. It's gonna put you in 3, but don't go there. I'm gonna send you back to 2. Let's move you around. Get anything?
Yes, I did. Thank you.
All right, this is case number 22242812. This is race check cashing versus HP Foreclosure Solutions LLC. The matter is before the court on a motion to set aside the entry of a default, and I believe a default judgment regarding this matter. Do I have anyone from race check cashing in the first instance? Anybody on this Zoom regarding raised check cash? Right, counsel for HP Foreclosure Solutions LLC, your appearance at this time, please.
Good morning, Judge David Applebaum, P78794 for the plaintiff. I'm sorry, for the defendant.
Thank you, counsel, and good morning to you, sir. So in reading the motion, I don't see the other side, but in reading the motion in this matter, it seems that there was a reissuance of a check or something that was supposed to resolve this, and yet the plaintiff went forward with entry of a judgment. Have you spoken with anybody since the filing of your motion on the other side, sir?
No, no one has reached out to me. I served the motion and no response. I also emailed it to the plaintiff's attorney, Brad Defoe, and I did not get a response.
Wow. It looks like it doesn't look like Mr. Defoe ever entered any appearance on this matter.
Yeah, I don't think an appearance was entered, but he filed the default though on behalf of the company, and obviously because the company can't, because it was originally in small claims and we removed it, and so I think that's why they hired Mr. Defoe, but Mr. Defoe never filed his appearance.
So tell me specifically, if you will, what's going on here? And there was seemingly you indicated there was a basis for filing the complaint relative to perhaps a check that was not negotiated or something didn't pass through. But then there was a replacement check that should have resolved this, is what my understanding is. Tell me about that, Mr. Allen.
Yeah, so I think the court accurately reflects what happened is that there was a check that was sent, but it was bad for some reason. My client reissued that check and it was cashed, and I don't know why I don't know why this complaint was filed because it was cashed. So I'm a little confused as to why this complaint was filed in the first place and why it's proceeded. I would also add, Judge, that I did file the answer in affirmative defenses, but it was never, I had the fax confirmation that was also attached, but apparently it never got processed. And that's the other reason for the good cause is that we filed the answer, but it just never got processed. But I have the fax confirmation attached to the motion as well. So I'm hoping that if the court were inclined to grant the motion, I can speak to Mr. Defoe and maybe we can get into a breakout room at a pretrial conference to get it resolved. So that's hopefully the goal here.
Well, it makes sense to me, and I don't know why the other side's not here, but I'm certainly inclined to grant the motion, and in granting the motion, the default in this matter, and the default judgment will be set aside at this time. I guess one of the things I was looking to is whether or not that would mean under these circumstances that the case should be dismissed. But I guess given that there may be another piece to resolve, that I'll set a pretrial conference date so I can review this matter in the future. So I'm gonna go ahead and do it that way, council. So I'm gonna set a pretrial conference date for the maybe do it on the 20th, the 21st of February. 2/21.
Okay.
And that'll be at 9:30 a.m. 2/21, 9:30 a.m.
Okay, do you want, Judge, do you want me to put that in the order, granting the motion to set aside as well?
Yeah, in fact, yes, if you'll do that, council, you have an email address to send the order to, sir?
Yes,
All right, that's, you got Carmen, Banks.
yes.
Okay, good enough. So.
Oh, I'm sorry, the order, how am I supposed to get you the order?
Yeah, send it to me by email, if you will.
Okay.
That's Carmen, CARMEN dot, the last name is Banks, BANKS. That's at 36districtcourt.org.
Got it.
All right, look forward to your order, sir.
All right, thank you.
All right, Mr. Whitty, welcome back, as well as Ms. Willis. Thank you, Councilman. That is on the, that's the suffix. Just 1 second here. There it is. Yeah, that's the suffix 6427. Council, update me at this time, if you will, sir.
Your Honor, Ms. Willis and I spoke in a breakout room. We don't have a resolution. We discussed different options, but she doesn't have the ability to make any sort of payment at this point. So Your Honor, I'll leave it up to the court how to proceed. I don't think she's disputing it. She'll certainly tell you herself, and I'm not sure she wants to come back. But if need be, the plaintiff would just file a motion for summary if the court isn't inclined to enter a judgment today, Your Honor.
Yeah, Ms. Willis, so the challenge is that I think it's pretty clear on the record that you don't have any dispute regarding the debt. You're just not able to pay. So it sounds like they would, the other side would be entitled to a judgment. The issue of collection, I mean, if you don't have, if all you have is a federal benefit, they can't garnish that. They can't collect, and if you put that money in a bank account, they couldn't collect that. But if you had money outside of your benefit that you receive, then there could be efforts to collect on that. So Ms. Willis, anything you wanted to say to me at this time, ma'am?
No, I paid on this debt the entire time that I had it, even though I didn't have income coming in. I was borrowing the money to pay this loan because I didn't start getting Social Security until 2 years after being diagnosed. So I'm just like stressed and strapped to the max. But I tried to pay it back. I just couldn't afford it anymore.
I understand, ma'am. All right, so it seems to me that that there's no issue of dispute on the debt. The question is whether or not they'll have a way to collect it, ma'am. And so there is no dispute that there is a debt. So I'm going to allow the plaintiff to present a document, a judgment document for the indebtedness, because there is no dispute here. Both sides agree that there is debt. Now, collecting on that debt, like I said, if you don't have any resources, it'll be a judgment out there, but there won't be anything they can do unless unless you came up with another job or something that would allow for collection. But if you're on disability, they won't be able to collect anything on disability. You understand?
Yes.
All right. And I certainly wish you well as it relates to the sarcoidosis diagnosis. I'm particularly familiar with that because I lost my wife about 17 years ago, and that was the issue. So I know the pathway that's involved in that, and I'm glad to see that you're doing as well as you are. You know, the sarcoid attacks various organs like lungs, and in our case, it was kidneys. So, but anyway, so I understand I understand what you're dealing with in a particular kind of way, and I do wish you well as you navigate that. That, of course, should be the primary concern of your life. The indebtedness stuff, there's not much that you can do with this. You could, of course, consider bankruptcy and hiring someone to address it in that way. But short of that, if you don't have anything to pay with, then it won't be able to collect anything. All right, so I do wish you well, counsel. I will allow the judgment on essentially an oral motion for summary disposition. The court on its face finds that there is no genuine material issue of dispute between the parties on the debt. Ms. Willis is pleading hardship issues, and those hardship issues are quite valid, but there is now no law that allows those issues to prevent the entry of the judgment. And so the court will allow the entry of the judgment where there is no formulation nor any claim of any factual dispute regarding the indebtedness. And I'll receive an order in that regard. Again, counsel, you may submit that to the court by way of email, and I'll get that order in. All right.
I did get that email address, Your Honor, and just for the record, the judgment is $10,906.13. This client will waive their court costs, and they'll also waive judgment interest. So I'll note that on the judgment as well.
Thank you. And ma'am, you'll receive a copy of that shortly after entry. And again, it's not something that you should stress over, because if you don't have any resources, you don't have any resources. And your federal resources are exempt from any garnishment or anything. All right, I wish you well. Be well, ma'am. All the best. Thank you, counsel. Good day to you.
Thank you.
Both.
All right, Madam Counsel, Ms. Nelson, I'm addressing now the matter. I think that's the suffix 838. That's D and F versus Hector Vesquez. That's the one you're on, Madam Counsel.
That's correct, Your Honor.
All right, thank you. Do I have Hector Vesquez on this Zoom anywhere? Any person connected to Mr. Or to Hector Vesquez? Say something at this time. All right, counsel. Again, the court previously set aside a dismissal on this matter, and that was based on the fact that there was sufficient showing that service was properly made prior to the case even being dismissed. Your pleasure at this time, Madam Counsel.
Your Honor, we would be requesting a default judgment here. As you stated, that default was entered at the end of September. That was mailed to Mr. Vasquez on October 20th of 2022, and he's yet to enter an appearance in the case or raise any sort of issues. So based on his failure to join issue, we would be asking for that default judgment.
And that default judgment is requesting the total sum of $1,542.23. Is that correct, Madam Counsel?
That is correct, Your Honor.
The judgment will enter at this time by default for the reasons set forth on this record, and in particular, given that the defendant did not appear at this hearing and has not otherwise responded to the complaint in this matter. So the judgment is entered at this time. Counsel will get a copy of that out right away.
All right, thank you, Your Honor.
And just one moment, coming to you, Mr. Burke, and Ms. Chappelle. Just a moment here. Okay, we're back on the record regarding the suffix 751, Beaumont versus Chappelle. Before the court on a motion for summary disposition. All right, Mr. Burke, update me if you will at this time, sir.
Thank you, Your Honor, and thank you for the breakout session. Ms. Chappelle and I did reach a resolution regarding a consent judgment. And with your permission, I'd ask to withdraw orally or at least hold in abeyance my request for a summary disposition. I'm going to prepare a consent judgment, email it to Ms. Chappelle for her to review and sign. And when and if she does that, return it back to me, and then I will get it right to court. And I do have your court's email, as you know.
All right. Ms. Chappelle, that makes sense to you, ma'am? Ms. Chappelle, it makes sense to you that a consent's going to be drafted and sent to the court?
Yeah.
All right. All right, so what I'm going to do is I will set a control date on this. Let's set it 38 cents or March 1st. Let's put it there, 3/1/23. And obviously, if the order is all signed and sent back to Mr. Burke and then sent to the court, that date will not be utilized. But if for some reason there's been a hitch or anything, some problems, I will hear this matter at 9:30 on 3/1/23. That's a control.
Thank you, Your Honor. Thank you.
I wish the two of you all the best to you.
Have a great day. Thank
Wait,
you.
I'm a little confused. You said we got to come back March 1st?
If for some reason, what's going to happen, Mr. Burke's going to send you consent that you guys agree to. If you sign it, get it back to him, then you won't have to come on that.
Okay.
If for some reason he doesn't get the document back or something happens, that's a control date for me to bring the case back to see what's going on.
Okay.
You sign that paper, send it back to him, then don't worry about the March 1st date.
Gotcha.
I wish you well, ma'am. Good day to you.
Good day to you.
All right. Case number 22-243399. This is Roderick Skipper versus Victor Rogers. The matter is before the court after a motion to set aside a default was entered. The court granted that motion, setting the default aside, and set this matter up for a hearing on today's date. All right. Do I have Roderick Skipper on the Zoom? Roderick Skipper. Do I have Victor Rogers on the Zoom?
Yes.
All right. Good morning to you, Mr. Rogers. Let me see, do I have, yes, there was a Roderick Skipper, Victor. Oh, okay, looked like the names are repeated a couple of times. All right, so I did set the default aside. I guess you filed the motion for me to do so. Is that correct, sir?
Yes.
So what's going on here? Roderick Skipper says that there is a dog that was taken and should have been returned. And
A dog.
no, that's a different case. I'm working.
Oh, I was getting ready to say it. That didn't sound right.
Yeah, that's a different case. All right, this case involves, he says that you sold him a lot that was never owned by you.
And I have the quick claim deed for the property and the real estate company that actually gave me the lot. What he was saying is definitely not true.
All right. So when's the last time you spoke with Mr. Skipper?
Oh, wow, it's been, it was before all of this was filed. I tried to talk to him and he told me that I sold him a lot that I didn't own. And I told him that I hid the paperwork to substantiate that from the real estate company that I got it from.
All right. Well, he's not here, and I'm not sure why he's not here. Sometimes what happens is when you get, and that may not be the case here, but sometimes what happens is when you get a quick claim deed, that means that the company that you get it from, or whoever you get it from, they're saying that whatever interest I have, I give that interest to you. Or if they don't have an interest, then they quick claim something to you that they don't have an interest in. And then if you sell it to the next person, then you're selling them something that you don't have an interest in. So it could be that kind of problem, but in order to litigate that, Mr. Skipper would have to show up. And we did send him a notice regarding this issue for today's date. So I'm going to go ahead and dismiss this case where the defendant did not, it's right there where the plaintiff did not show up. So the case will be dismissed. If they want to go forward, they will have to petition the court to reinstate the matter. Right. I wish you well, sir. Good day.
Thank you. Have a good day.
You too.
What we get?
All right. Case number 22. Uh, 197760. This is Crystal Walters versus Maurice Branch. Matters before the court on a petition for claim and delivery. This matter is set on today for 9:30 a.m. This is a case that involves a claim that an animal, a dog that belongs to the plaintiff, has been withheld by the defendant. The defendant filed a motion for possession pending judgment. The court denied that motion on the 30th of November 2022. A notice of hearing was sent out on this matter at the same date, setting a hearing, a pretrial hearing on this file. Neither party has appeared for this hearing that was set again for 9:30. It's now 10:20. This case will be dismissed at this time. Let's see who this is connected. All right. I'm sorry.
That's that case you just did. Skipper Roger, Victor Rogers.
Yes, Mr. Rogers had a quick question. We pushed leave too quick. So he had a question for the judge real quick.
All right.
Yeah, I just wanted to get a copy of the dismissal. How would I get that?
Who's the lady?
That's my wife.
Oh yeah, what's your name? You have to put your name on the record, man.
My name is Carmen Rogers.
All right, thank you, Ms. Rogers. I knew there was some lady involved for me coming back in my courtroom. You can't have your business without your wife.
Exactly.
Yeah.
Don't answer that question. Yeah, of course, you know you're gonna get a copy in the mail. Okay?
Okay, thank you very much.
Thank you.
Good day to the two of you. Bye-bye.
Okay, bye-bye.